What if you're innocent? What if you're framed? What if the state puts people on the stand who they know are lying so that they can get a conviction out of you while these guys took a deal? Is it because the state of Florida and all the other states in our union put people on the stand that they know are lying? They pay them, they coach them, they depend on them to lie on that stand so that they can get that guy convicted, knowing that guy's not the guy, not the one. They don't care. It's about a conviction. Remember? What's the end goal here? Oh, that's right. Become a judge. Can't become a judge if you don't win. What if you're innocent? Go to prison and die? That's what Judge Hirsch wants. Finality. Judge Hirsch goes on to say jurors are entitled to know that when their jury service is completed, the criminal justice system will let them go in peace. It will not pepper them endlessly with questions, demands, inquiries. If that is not the case, if a juror having completed his service is subject to being probed and pestered, harassed and hectored, perhaps for years, perhaps for decades, then the sanctity of jury service exists no more, and no sensible, fair-minded person will want to perform the duty of jury service. Again, tell the truth, you have nothing to worry about. But what if somebody came in, Judge Hirsch, and lied to your face, withheld, concealed a bias against the defendant? You're okay with them being wrongfully convicted because you don't want these jurors to be probed and pestered, harassed and hectored for years or decades? How is that fair? Well, it's not. On page 13, Judge Hirsch said, what then would a sensible, fair minded veneer person think if he or she were to read the chilling language on Covert Ops website? Its message is clear. Serve as a juror if you dare, but know that if you return a verdict displeasing to Covert Ops and its clientele, Covert Ops will pursue you endlessly, as relentlessly, as callously as the law enforcement officer in Les Mis. And not just you, your loved ones as well, your children if necessary. Live as long as you may, you will never outlive the shadow of your jury service. Decades from now, a lawyer bolstered by the facts or the misrepresentations that Covert Ops has scavenged from public records and from that rat's bone of fact-finding social media, it may demand a hearing at which you will be placed under oath and ask if you committed the crime of perjury when you omitted to mention some obscure incident long since lost to memory from the life of a distant relative. But the minatory language of Covert Ops website, although directed to jurors, is not confined to jurors. It extends to jurors, here we go again, family and friends, and everyone associated with the case, accusers, victims, and their family and friends, law enforcement, witnesses, all courtroom personnel. Yes, exactly. And do you know why we do that, Judge Hirsch? We do that because we have found connections between jurors and courtroom personnel. We have found connections to jurors and accusers, and jurors and witnesses against our clients. That was not disclosed during jury voir dire because the juror lied. That's okay with you? That's okay? If somebody comes in and says they don't know anyone that's going to be testifying at court during trial, come to find out two of those key witnesses against our client are his cousins. You're okay with that? I'm not. Our client certainly isn't. And then to find out that, yes, we continued to dig to find out what was the motive. Why would somebody with a master's degree and a family lie about something so egregious to get on the jury? Well, because this family of the juror was longtime friends with the victim's family. There you go. That's okay with you, Judge Hirsch? Because it's not okay with me. It's not okay with my company. It's not okay with anyone who works with us. It's not okay with the attorneys that work with us closely. And yes, Mr. Savy, who is an amazing, godly man and a brilliant attorney. He did not deserve this. Then he claims Mr. Pierre, having exhausted all legal remedies and avenues properly available to him, waited a decade and a half to bring the motion at bar. No reason deserving of any weight is offered to justify the delay. And in the other scale is the appalling justice to and the shameful treatment proposed to be visited upon jurors who honestly and reasonably believed that they had completed their civic duty nearly 20 years ago. Honestly, you think that's what happened here? He said the motion at bar poses a question whether all judgments and sentences, however fairly and lawfully obtained, are amenable to sabotage decades after the fact if opportunists are, so now we're an opportunist, are sufficiently determined to spy and pry into the lives of jurors and their families until some trivia about them is unearthed. The answer to that question is no. Defendant's motion for post-conviction relief is respectfully denied. This is a final order. No motion for rehearing will be entertained. So ordered in chambers in Miami-Dade County, Florida, this 25th day of July, 2025. Honorable Milton Hirsch, Judge, 11th Judicial Circuit. Well, let's talk about that for a minute. First off, you go to trial. No one tells you to even look at the jury. In fact, they tell you not to look at the jurors. When the jurors, and I'm there, I was there many times. I can attest to the fact that when the jurors come and go, everyone stands out of respect and you look down. You don't look them in the eye. You don't notice them. You don't pay attention. They're over there. You're looking at the witness box during trial. You're not even paying attention to the jury. As I've said before, I know of men who have called me from jail after having just been convicted and taken back to the county jail, and they can't tell me if they had 6 or 12 jurors. Week-long trials. They are so traumatized, they can't even tell me if they had 6 or 12 jurors. Not only do they not know who these people are, they are not told by anyone in that courtroom, hey, if you suspect that the verdict was tainted, or if the verdict is wrong, if they got it wrong, you can investigate them. In fact, in Florida, you have 10 days post-trial where the defense attorney is supposed to look at the jury. We've been hired in almost a dozen cases to get involved within that 10-day window and find something on one of the jurors that was not truthful, not disclosed during voir dire. Thank God we've been able to do that in every case we've been hired to do. So you're supposed to investigate the jury, but most defendants are never told that. The attorney files a motion to withdraw. The trial court's over. Appeal is filed. The record is closed. You're done. And yet all of our cases that have gone back to court, the judges are saying you could have found it in time to raise it in that direct appeal. Well, how is that? When you didn't even know who the jurors were, you weren't told you could find out who they were. I would imagine once you've been convicted, if you ask the clerk of court for the addresses, you're probably not going to get them. I have to pay for them and then promise to do them no harm. That's how I got our jury addresses after Martin's trial. So you go to county, you're at county, sometimes within days, you're sent to prison. No internet access, no legal representation, no knowledge that you can even investigate the jurors. And so you begin the arduous process, grueling, painful process of appealing this conviction. At no time in the system does it say, oh, and maybe you should challenge the jury verdict. So here, yes, you come to us 20, 30 years later. No one has told you you can challenge the jury verdict and that you should. In fact, I don't know of anyone else in the United States, or I want to say is the world. I don't know of anyone else who has a company that solely our sole purview is to investigate the juries. To know what? Did you tell the truth? If you told the truth, great. We applaud you. You did your civic duty. That should be commended because we find that that's not always the case. So, yes, you come 20, 30 years later, you have gone through all the proper channels, just like he described with Olson. You've appealed to this court, you've filed this Habe, which is a federal motion. You have done all the things. You've argued a legal sentence. You've done everything you know to do, everything the courts tell you to do to challenge your case, and you get denied, 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 denied. What's left? Nothing except the jury. So, yes, that's why it takes 20, 30, 38 years for one of our clients to know that you can investigate the jury. Now, how do you do that? Besides hiring us, I don't know, because we've spent a lot of time and a lot of effort coming up with a system that is proprietary, in my professional opinion. It's not shared, and it works. But the reason it works is because we are relentless, because we don't stop until we find it. We know it's there. We know somebody lied in every jury. We know they did. And why do we know that? Because the cases that we investigate have actual proof of some sort of innocence. When you filter the guilty verdict through the case and even the little bit of truth that's shared at trial, it would have been a hung jury, a not guilty, or a mistrial. But when you filter that guilty verdict through the fact that you had a biased juror on your jury, it's the only thing that makes sense. It's the only thing that makes sense to our clients and their families and the attorneys who represent them. So I do take issue with this cherry picking of what you think about us. As I tell you what we found in Olson's case, I want you to sit there and think about, if you were falsely accused of a crime, a violent crime, would you want this juror sitting on your jury? Would you want this juror to go back in that deliberation room and become the foreperson? Don't know how he became the foreperson, if it was self-appointed or because of his connections to law enforcement. The other jurors felt like he would be the obvious choice. Don't know, but he did become the foreperson and delivered the verdict to the court. Would you want this person on your jury? There was a questionnaire that was asked of the jurors to fill out. We don't have the filled-in questionnaire because the clerk of court destroyed it. I'm going to talk about that in our next cases too, in every case, how we go to find records and they're destroyed. Addresses are destroyed. They won't even tell us where they sent the checks 20 years ago. Why? Because they've destroyed those records. Well, if you have the right to a fair trial by an impartial jury, why are you destroying records? Well, because you don't want them looking at the jury. You don't want us challenging the jury verdict. I have a blank copy of that questionnaire. Where did I get this? From the clerk of court. One of the questions on here was, do you have children? And then it said, please list child's age and occupation. Have you or a close friend or family member ever been the victim of a crime? And are you acquainted with anyone who's currently or formerly employed in the criminal justice system? And have you or a close friend or family member ever been arrested or accused of a crime? So these are some of the questions that were asked. We don't know what Mr. Moore answered, except we know what he was asked during the voir dire. So we have some sort of insight as to what he would have said on here, or what he did say, based on the questions that were asked of the state attorney and the defense attorney and the judge. Now, I want to preface this by saying that our client was accused and convicted of robbery, and there were drugs involved. In fact, this is a piece of the transcript I took. It's page 953, and it says they're explaining what happened. It just says they, Mr. Olson and the co-defendants, planned and premeditated what they were going to do. They were coming to take this man's life, money, and any drugs he had with him at the time. So the jurors who served on the jury knew during voir dire that this case involved drugs, substance abuse. Now, would you want someone on your jury who had family members with issues with drugs or substance abuse? I wouldn't, because you don't know. You don't know. I wouldn't take that chance. On page 235 of the voir dire, the defense attorney, Mr. Pierre's attorney, asked, "Let me ask Ms. Rivera, what about you? Somebody comes in, they got no bones about the fact that they deal drugs, they sell drugs to people for a living. Are you going to be able to weigh that person's testimony, give them the appropriate credibility for what it's worth? Would you have any problem knowing that the person is a drug dealer?" She said, "I might." Mr. Roush said, "You might have a problem with that. You might not be able to be fair and impartial knowing that he's a drug dealer." The prospective juror said, "Uh-huh." Then the court said, "Is that because you might not believe him? Is that what you're saying?" The prospective juror moves her head up and down. This prospective juror was honest. This prospective juror was excused. She did not serve on Mr. Pierre's jury. As I said, we take great pains to verify that the jurors we are investigating are the jurors who served on the jury. We don't leave anything to happenstance. We don't guess. We don't assume. We compare their questions and their answers very meticulously. In Mr. Pierre's, during the voir dire, Assistant State Attorney Frank Leedy, I believe is how he pronounced his name, was speaking to who became foreperson Charles Moore. And he said, "And the family and friends in the Department of Corrections, do you discuss cases with them?" So that's how we knew that Mr. Moore, foreperson Moore, had family and friends in the Department of Corrections. And then Mr. Moore admitted that he had a brother that was arrested. Apparently that was on his questionnaire. And Mr. Leedy said, "That situation with your brother, did you discuss the case with him?" Mr. Moore said, "No." "He took responsibility for his actions?" "Yes." "Excellent. Any impact on this case?" "None." Okay. Then the defense attorney, Henry Roush, was talking to Mr. Moore later in the voir dire, and he said, "Okay, I guess you have a child who is also in law enforcement as well?" Mr. Moore said, "Correct." Mr. Roush, "Any problem for you with that? Do you discuss work with your child?" Foreperson Moore said, "No." Mr. Roush said, "All right, as far as the incident with your brother, is that something that might affect your ability to be fair and impartial here, or something you can put aside?" Foreperson Moore said, "No, I can put it aside." And again, reiterated that he had a lot of friends and relatives in the corrections field. And Mr. Moore assured him he could be fair and impartial. Well, I take that back. The words were, "You can hold the state to its burden." Mr. Moore said, "Yes, I could." I've already discussed a little bit of what we found, and I'm just going to read a few highlights of this. Is actually my report that I wrote. We had over 100 exhibits attached to this, along with the verdict form and all the signatures we found, where we suspected that that was the Charles Moore who served on Mr. Pierre's jury. And again, the retention period, I was told, for the clerk of court for jurors' addresses and information is 2 years. 2 years. So even if you want to investigate the jurors 2 years after your conviction, good luck figuring out who they were, because the clerks of court destroy all records. And as I've said, this particular voir dire transcript had very little in it for us to go by. This is some of the things we found out. So foreperson Moore was not asked to discuss his brother's cases. Is that because he and his friends and family and his son were all law enforcement? Is that why he wasn't further questioned during the voir dire? They just took him at his word that he could be fair and impartial? I don't know. But what we found out about his brother was that he had, just prior to trial and dating back to 1989, cocaine, consuming, possession of drug paraphernalia, more cocaine, possession of drug paraphernalia, there's 6 cases, possession of drug paraphernalia and cocaine. So his brother had a drug problem. He wasn't asked that, though. Maybe he felt like he could be fair and impartial. Okay, and he did disclose it, so have no issue with that. Should he have been chosen for the jury? Probably not, but he wasn't asked to disclose. He wasn't asked to elaborate, I should say. So we knew that according to foreperson Moore, his brother was in Tampa. So we made public records request of Hillsborough County Sheriff's Office, Tampa Police Department. The Tampa Police Department sent us records, violation of probation, cocaine, consuming alcohol on the street, possession of controlled substance, use and possess of drug paraphernalia, and his sister, foreperson Moore's sister, was listed in this case as well. So what are the odds that foreperson knew about his brother, but did not know that his sister was also mentioned in these cases? In fact, the officer wrote, post Miranda, Sharon McDaniel stated, foreperson Moore's sister, she has smoked crack cocaine, but those pipes are not hers. She only drinks alcohol. So now we have a brother and a sister with substance abuse problems. So then we began to focus on the sister. And when we did, is when we found the lawsuits. Now, why is that important? Because jurors are asked if you've ever been a party to a lawsuit. I'm not really sure where the bias is there, but that was another thing that foreperson Moore was not truthful about. Continued searching of online newspapers revealed that accident with his mother that took her life, and the fact that his father was drunk and is the one that had the accident when his mother died. Again, more substance abuse. Is that somebody that you want on your jury when the basis for the crime that you've been accused of was drugs and theft of drugs and money for more drugs? We found that his sister, Sharon McDaniel's background report showed that she had multiple criminal cases in Hillsborough County, Florida. Aggravated battery, great bodily harm. These were just a few years before trial. Aggravated battery, great bodily harm with a weapon. Possession of open container, possession of open container. And again, in and of itself, the open containers could seem trivial. But when you put the whole big picture together, it does paint quite the picture. Then we asked the Tampa Police Department for records. And again, notice how many times we're making public records requests and paying for them. This is not something you can do from prison. This is not something, even if you knew how to do, you would be able to do from prison. So the Tampa Police Department came back with records on foreperson Moore's sister. This was 5 years just before trial. So it's not like it was so long ago that he forgot. Aggravated battery, domestic violence. According to the report, Sharon McDaniel used, that's foreperson Moore's sister, used a sharp object to cut the right arm of Melvin Williams, her live-in boyfriend. The laceration was approximately 6 inches in length and approximately 1 inch in width. She appeared to be heavily intoxicated, according to the police report. The next year, in 2002, aggravated battery, domestic violence. According to the report, she stabbed her living girlfriend on the left side near her rib cage with a butcher knife and pulled out some of her hair. She was no longer at the house when the police arrived. Again, alcohol was suspected. A few months after that, aggravated battery, domestic violence. According to the report, she stabbed her living girlfriend again in the leg with a large pair of black-handled scissors. Ms. McDaniel appeared to be heavily intoxicated, according to the law enforcement officer. 3 months after that, possession of crack cocaine and possession of paraphernalia. This report is not legible, but it appears to be a repeat of the report we received earlier on foreperson Moore's brother, Michael Moore, which involved the sister. Judge Hirsch cherry-picked and made it sound pretty trivial. And I have to admit, if all I did was read his order of denial, I would have said, yeah, that was probably a waste of the court's time. If that's all you had, really, where's the bias? Where's the egregious behavior by a foreperson? But as I said, there was so much more. So much more. The most concerning to us, and from what I can recall with all the many conversations with Attorney Savy, was the fact that this foreperson said his son was in law enforcement. Well, he said child, but his daughter was never in law enforcement, and the son was never in law enforcement. In fact, we sent records requests to the Miami-Dade Sheriff and Police Department and the Florida Department of Law Enforcement. We waited a long time to get those records, and we discovered that his son not only had never been in law enforcement, according to these agencies, which said no records exist dating back in time to the beginning of time when he was born, no records existed for either of foreperson Moore's children, but yet he admitted and claimed that one of them was in law enforcement. We found that his son had records, again, 3 years before trial. Guess what? Drum roll, marijuana possession, and petty larceny theft and petty larceny theft, 2 charges. The offense report that we found 2 months after Mr. Pierre's trial said that a foreperson Moore's son was arrested for the petty theft while working as a cashier for TJ Maxx. Not in law enforcement, working as a cashier. He said the witness advised that on the listed date and time, he observed Charles Moore Jr. set aside clothes in a layaway and give $200 worth of merchandise to another employee who did not pay for the merchandise and deprived the store of merchandise monetary value. Charles Moore Jr. also gave merchandise to another unknown subject, approximately $600 worth, who did not pay for the merchandise, and then gave $800 worth of merchandise away and was arrested. He was transported to the jail. Is this the person that you would want deciding your fate? Is this the type of person that you would want as your foreperson? I was a foreperson once. We carried quite a bit of weight. If I had said, okay, let's just vote and go home, that's what we would have done. We wouldn't have deliberated. We would have ate our state approved, paid for lunch, and everybody would have gone home. In fact, they're mad at me, as I've said before, because I wouldn't do that. I wanted to talk about it. I felt we owed these 2 young men that, and we did. I will say that foreperson Moore was employed as a correctional officer, so he was technically in law enforcement. He had either retired or resigned or was fired, I don't know, but before Mr. Pierre's trial. So at the time of trial, he was no longer working as a correctional officer, according to the the last date on the job, according to the HR, was February 28th, 2006. So months before Mr. Pierre's trial. Would you have trusted him? If he had disclosed the truth, all of that, do you think that they would have left him on the jury? I don't know, but I certainly would have asked for him to be excused. All right, so why is all this important? Well, it's important because you have a foreperson who is impersonating law enforcement. When you say your kid's in law enforcement and they're not, that was the hot button for us and for Attorney Savy, because you weren't truthful about everything involving your family that probably would have got you struck from the jury had you been. But where did I go? Well, I'm going to come back around to Judge Hirsch. I actually asked ChatGPT today, what are the responsibilities of a judge? It says judges have a wide range of duties, but their primary role is to ensure justice is fairly and impartially administered in legal cases. It said they are to ensure trials are conducted fairly, according to law and procedure. They are to protect the constitutional rights of all parties. They are to ensure legal proceedings are fair and follow established legal procedures. And they are to remain impartial and avoid conflicts of interest, and then to follow the judicial codes of conduct and ethics. Based on what you read, what I read to you, do you feel like Judge Hirsch was fair and impartial? Do you feel like he upheld Mr. Pierre's constitutional rights? Because I don't. I printed out just a few pages here as I wrap it up. In Florida, there are judicial codes of conduct. I'm just going to focus on canon number 3, which is a judge shall perform the duties of judicial office impartially and diligently. A judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, and others with whom the judge deals in an official capacity. Do you feel like Judge Hirsch was patient, dignified, and courteous in his response, in his denial? Number 5 says a judge shall perform judicial duties without bias or prejudice. A judge shall not, in the performance of judicial duties by words or conduct, manifest bias or prejudice. Do you feel that he maintained his impartiality when he wrote that denial? I don't. Number 6, a judge shall require lawyers in proceedings before the judge to refrain from manifesting by words, gestures, or other conduct bias or prejudice. You see a pattern here? Impartial, fair. We count on you for this. We depend on that. Our lives depend on this. A judge shall dispose of all judicial matters promptly, efficiently, and fairly. A judge shall not, while a proceeding is pending or impending in any court, make any public comment that might reasonably be expected to affect its outcome or impair its fairness. That order of denial, where is it going? To the 3 appellate judges. Sure sounds like to me that Judge Hirsch is telling them, don't even waste your time. This is absolute garbage, complete waste of time. And oh yeah, Mr. Pierre, yeah, he's time barred. How can you be time barred when you don't even know you can investigate the jury? It wasn't like he just sat around and waited till all of his appeals were denied and then said, all right, I'm going to give a Hail Mary to Covert Ops Jury Investigations and see if they can find something so I can get back in court. It's called fighting for your freedom. And that's what Mr. Pierre has done, along with his family, for over 20 years. This particular portion says a judge shall diligently discharge the judge's administrative responsibility without bias or prejudice and maintain professional competence in judicial administration. Not go to somebody's website and cherry pick what works for you and leave out the truth. A judge shall require staff, court officials, and others subject to the judge's discretion and control to observe the standards of fidelity and diligence that apply to the judge and to refrain from manifesting bias or prejudice in the performance of their official duties. What kind of example are you setting to the people that you work with every day? A judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances where the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of disputed evidentiary facts concerning the proceeding. You certainly seem to know a lot about this case. The duty to hear all proceedings fairly and with patience. That's another canon. A judge must perform judicial duties impartially and fairly. You see a pattern here? A judge who manifests bias on any basis in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. Facial expression and body language, in addition to oral communication, can give to parties or lawyers in the proceedings, jurors, the media, and others, an appearance of judicial bias. A judge must be alert to avoid behavior that may be perceived as prejudicial. And lastly, the requirement that judges abstain from public comment regarding a pending or impending proceeding continues during any appellate process until the final disposition. Well, that's where we're at. Judge Hirsch denied the motion, denied the opportunity for a rehearing, and said it's final. So now it has to be appealed. And if I'm an appellate judge and I read that order, which they will, I would think twice about even bothering with it. I pray not, because our client deserves better. Our client deserves impartiality. Our client deserves fair. He deserved a fair trial. I don't believe he got one. Neither does Mr. Savior. He would not have taken the case, and he wouldn't have written the motion. I know our client doesn't feel that he got a fair trial, and neither does his family. I believe, based on what I read in the order of denial, that Judge Hirsch seems to think that we might investigate him and his friends and family, and no. Not unless we get a case in which he's presided over. Yes, then we would. But in this case, no. I did, however, looked him up just to see what kind of person that he was. That's how I found some of those articles. And then this was something I'm going to end with because I thought this was very interesting and very telling. The article is called "A Few of Least Favorite Things of Judge Milton Hirsch." There were only 2 comments that I'm going to focus on. There were others, and I'm not cherry picking. Most of them were favorable towards him. I'm just not going to read them on here, but you're welcome to go look them up. Somebody said, Hirsch hates when family or friends of an in-custody defendant stand up and attempt to speak on their loved one's behalf. Always shuts them down with extreme arrogance. That was in 2023. And then a little later in the feeds, someone said, reading through all of these and just realized I should have read these prior to going in front of Judge Hirsch. I saw a comment where someone said the family of a loved one tries to speak, he shuts them down. I can 1,110% agree to this. Loved one passed away, and at plea deal hearing, he was annoyed I wanted to read my victim impact statement and constantly used his hand to motion me to hurry up. It seems to me that Judge Hirsch isn't really interested in the truth. He hasn't even entertained the thought that someone could be wrongfully convicted by the state and co-defendants who lie on the stand, or ex-wives and stepkids. Hasn't even considered the fact that jurors come into court and lie to your face. Why? Lots of reasons. They want to be famous, vigilante justice. Maybe they don't like you. So I guess Judge Hirsch, the wheel of justice. Yeah, that's you. But the scales in your courtroom are not balanced, as evidenced by your words. And Lady Justice isn't blindfolded. Nope. Looking the other way. If you've been wrongfully convicted or you know someone who has, and you need our help, you will find our contact information in the description below. I hope and pray that judges will take the time to consider that maybe, just maybe, the person sitting at that defense table is innocent. Thank you for watching. Like and subscribe. I would be honored. I look forward to next time. Remember, the courtroom may be silent, but we won't be. So speak up, speak out, and always speak the truth.